it appears clear to me that you need some long-term residential treatment. If for no other reason than in the last 6 years, you've had 6 different felony arrests, 3 different felony convictions, and you've had several different cases dismissed that were drug related, all that appear to relate to narcotics or methamphetamine, all appear to be fairly low level. And what I mean by that is you're really harming yourself, but I don't have one charge. It was a delivery related, but it ultimately was dismissed. There don't appear to be a ton of aggravating circumstances, except that it's repetitive. And that, as the prosecutor indicated, if you continue to come back into the court over and over and over again, there's less things the court feels like are necessary to do other than just simply be punitive.
That's right.
I don't have an issue with you getting into a treatment facility. If you can get into an inpatient treatment facility, I'll allow you to be released. You've served 103 days in jail. I don't think that's particularly enough, but if you can get into a residential treatment facility, a long-term facility, and you have an inpatient bed, I'll allow you to be released from the Kalkaska County Jail immediately. If you show proof that you've successfully completed that treatment, at least 30 days long, then I'll give you day-for-day credit for the rest of your jail sentence, and you don't have to turn yourself back into jail. I want to give you an opportunity to do that. But if it's not inpatient, if you don't get it set up, then I'm simply going to impose a jail and you're just going to serve it and then you'll be done. Whether or not it happens while you're in jail or not, though, you should remember what you're saying to me right now. You think you're in need of treatment.
Yes, Your Honor.
You should get into treatment, whether or not it saves you some time in jail or not.
Yes,
Because if you don't, the police are aware of who you are. They're going to be able to see if you're using controlled substances, and you'll probably be right back to it again. So I think the recommendation makes sense with the added provision, as your attorney requested, that I allow you to get into treatment if you have a bed secured. So you're going to need to prepare a separate follow-up order, Mr. Travis, that indicates that. I'll have it in the judgment of sentence, but it also needs to indicate all the language that I typically require, which is he needs to transport himself immediately to the facility, back to jail if there's any sort of discharge unsuccessfully, anything other than a successful discharge. If he's successful, he does not need to turn himself back into jail. The court will order 180 days in jail with credit for 103 days that you previously served. Outside of that, Mr. Johnson, the fines and costs, which are mandatory in this case, will be imposed by the court. And that would be as recommended, which was the crime victim assessment of $130, court costs of $325, attorney's fees of $350, a DNA testing fee of $60, and a $68 state cost. Those fines, costs, and assessments are due today. If they're not paid within 56 days of today's date, a 20% late fee gets added on. You do have the ability to ask the Court of Appeals for leave to appeal. If you wish to ask for leave to appeal, go through those appeal rights. Good luck getting into a facility, but please take it seriously and get into a facility, whether or not you do so during jail with it.
Yes, Your Honor.
Good luck.
Challenges that I received, I think, on the 26th.
Okay. And is that the reason why I just received your response today, because of those same timing issues, Mr. Ziegler?
And Mr. Horowitz had to look into these issues and file his brief. I understood. I told him earlier in the day that he could file it. I wouldn't object to the timeliness. I got it yesterday afternoon and I filed mine probably after hours yesterday.
All right. And so the court is in acceptance, it accepts each of those statements. And we'll go through those scoring guidelines objections individually, each one of them from each attorney. The court would note that because this is a victim against a crime victim's offense, a crime against a person, there is the ability to have, obviously, the victim allocute. And because the factual questions involve potentially what a victim would say, the court's going to hear from any victim that's here, if they're here, before I make determinations as to the offense variable scoring. Did the people wish to be heard on that?
Your Honor, I don't believe the victim is present today.
All right, then that takes care of that. And did you wish to make any statement for purpose of appellate review on that point, Mr. Horowitz?
Not for appellate review. I would just note that witness victim is on DOC monitoring, so the people, everybody knows where she's at. She would be available today if she chose to be here.
Sure. And so in other words, what you're saying is there's not, there shouldn't be any finding by the court that somehow she's unavailable because she wasn't notified. She was notified, she just chose not to be here.
Correct.
Do you have any response to that suggestion?
No, Your Honor.
Let's go through the guidelines challenges first, and then we'll cover if there's any corrections, additions, or deletions. So who prefers to go first? Defense, do you want to state your objections, and then we'll hear the prosecutions?
I'll go first. That's fine. So thank you. As to the prior record variable objections that I made, the PSI considered two that I don't believe should count. One was the UDAA attempt, which is a low severity felony, should not be granted under PRV5. The other is the taking of a turkey, deer, or bear, or whatever, illegally. As to that, I classified that as a regulatory hunting offense and not one of the offenses that are enumerated by the statute, or types of offenses that are enumerated by the statute for scoring a PRV5. Well, people responded that, things with weapons would count, and responded with a couple of examples of things that would count. One was OWI with an ORD. That's specifically cited by the statute. That's specifically enumerated. So that doesn't help the argument, or the people's argument, rather. And the second was the use of a crossbow or in a vehicle, a loaded crossbow in a vehicle. I'd say that by definition would be a weapons offense, because it is possessing a weapon is the primary elements of that offense. As to Mr. Wiesner's offense, we don't have that record in front of us. There's no indication that a weapon was involved. I think that maybe the assumption is that a weapon would be involved, but it is not one of the elements of the offense. There's just taking one of those animals illegally. And of course, some of the animals within that statute can be taken via trap illegally. So there's nothing that says that was a weapon offense. And moving on to
Let's take them one at a time.
Okay.
Just makes it easier in my mind. Mr. Ziegler, your response to the scoring of PRV5 because of the misdemeanor convictions, or regarding the misdemeanor convictions?
Your Honor, as to the taken deer, bear, turkey issue, I would say that the term weapons offense is not defined anywhere that I could find in a brief search last night. To my eyes, the logical definition would be any offense where the possession of a weapon is a required element or a required part of the offense. In this case, I don't see any reasonable way that one could take a deer, bear, or turkey without employing some kind of dangerous weapon, be it a gun, a bow, a slingshot. Mr. Horwitz suggested a trap. I would say that a trap that would allow someone to trap a deer, bear, or turkey by definition would also be a dangerous weapon. I simply don't see how you could construe that statute where the element is the taking or hunting or collecting of that animal.
Well, without getting an accident and I drive my truck into a deer, the deer dies. I don't seek permission from the DNR. I load the deer into my car and I get pulled over by police later. An accidental hitting of the deer with my vehicle. I wasn't using my vehicle as a weapon, but I accidentally hit the deer. I load the deer into my vehicle. I'm illegally possessing it. Also, I've illegally taken the deer, and I didn't use a weapon in that scenario, right?
I would say that if you use the vehicle to enable you to take the animal, then the vehicle was used as a weapon, whether intentionally or otherwise.
You had an accidental scenario?
I would say that the vehicle still constitutes something that it may cause serious injury or death, and therefore constitutes a dangerous weapon under the law.
All right. Any further argument on that particular?
As to item 6, no, Your Honor, but I would note that there was another item that I noted in my brief. I think it was item 26. I'm just going through my brief here. Item 27, Your Honor, was a domestic violence conviction that I don't think either the defense or the PSI author looked at, but it's clearly qualifying. So even if the court doesn't accept my argument as to item 6, there's still 7 qualifying misdemeanor convictions. I would concede the UDA.
Mr. Horowitz, what about the domestic violence conviction?
I don't have any argument about that.
The scoring at PRV5 remains accurate then, and it remains accurate irrespective of what I determine with regard to the hunting or the illegal taking of a deer, bear, or turkey, because it remains the case that the defendant has 7 prior scorable misdemeanors because of the domestic violence offense. The court also agrees, of course, the UDAA attempt is an attempted felony. That's not a misdemeanor. But the taking deer, bear, or turkey is a closer question. I'm not going to score that as a prior scorable misdemeanor. I'm going to correct the PSI to indicate it's an unscorable misdemeanor. I think there are circumstances where you could take a deer or bear or turkey without possessing a weapon. I think probably the vast majority of offenses, and if I had more information, I could certainly score it by preponderance of the evidence. The vast majority, I think, of circumstances where taking a deer, bear, or turkey in a wildlife conservation violation do involve weapons. But I don't have the specific facts, as Mr. Horowitz pointed out in this case, to make that determination. I could only guess at it. And so I'm not going to score that as a misdemeanor. But because of the existence of a domestic violence conviction, which was not otherwise scored, there are 7 prior scorable misdemeanors, and the PSI remains accurately scored. The scoring remains accurate on that. As to PRV, OV10, excuse me, Mr. Horowitz.
I think OV10 is a much easier case, Your Honor, a much easier question. And OV10 assesses points for exploitation of a vulnerable victim. It requires that the victim be vulnerable within a certain class of characteristics, although it's not limited to those. The court could find something outside of that that makes a victim vulnerable. And it requires exploitation. Both vulnerable and exploit are defined under the statutes. Neither of those apply to this case. This was a fight in a trailer where you have 2 people that were roughly the same size, 170 pounds, 175 pounds. We don't have evidence about their relative strengths or weaknesses.
Well, we have inferences from the evidence. We have the inference that the defendant pled guilty to a felonious assault where he, in his terms of his plea, he threatened somebody with a dangerous facts in a PSI, which as of yet at least haven't been challenged as inaccurate, that suggests that the defendant punched the victim, strangled the victim, as is going to be argued by the people, and otherwise held her down and tried to rip her pants, or did rip her pants, in holding her down and assaulting her. Those are all facts that are in the PSI, right?
Yeah, I think those would be facts that would be common to most or many felonious assaults and similar crimes that would not involve a particular vulnerability as defined by statute or exploitation as defined by statute. Those are certainly unfortunate facts, but those are the criminal offense or the cloud of the criminal offense. The exploitation means taking advantage for these specific purposes, profit, gain,
Or manipulate.
To certain ends, right? And then the vulnerability means something that makes the person particularly susceptible. And then the instructions go on to explain that just merely having one of the characteristics isn't enough. You got to explain how, there has to be a connection as to how that vulnerability actually was in operation and how it came to be exploited. And that's just not what we have here. There isn't a huge size differential, but more importantly, there's no proof of exploitation. There's no real argument even as to how somebody was exploited in the sense of the statute, or how somebody was unduly sensitive or have a vulnerability as defined by statute. That's just not, to my mind, it's not even an argument. So I believe that should be scored at 0 points. The people kind of up the ante and say, hey, there's predatory conduct. Therefore, it should actually be scored higher. There is pre-conduct in this case, alleged, but it's not predatory insofar as it still doesn't relate to a vulnerability or an exploitation as defined by statute. This is really, I think, probably the most common example where you see this scored appropriately is in cases where an adult exploits a child and exploits that child's youthfulness and inexperience that makes that child vulnerable in a particular way, and that adult exploits that child usually for personal ends involving sex acts one way or another. That is where we see exploitation of a vulnerable victim, or somebody that has an intellectual disability, or somebody that has a physical handicap, or somebody that has is particularly aged as to make them reliant on a caretaker. This is just not one of those situations. Thank you.
Thank you. Mr. Ziegler, your response to OV10?
Your Honor, I think OV10 is properly scored at 15. I cited People versus Cannon where they discuss the standards for predatory conduct. I agree with Mr. Horwitz that those types of cases he described are primarily where we see predatory conduct, but the statute and the OV make no stipulation as to those are the only kinds of cases where we can see predatory conduct. Case law says there's 3 questions for the court to consider. Was there pre-offense conduct? Was it directed at one or more specific victims who suffered from a readily apparent susceptibility? And was the purpose of the pre-offense conduct for victimization? I think for the reasons I stated in my brief, all of the answers to those questions are yes. Mr. Wiesner went looking for Miss Berge. They had just ended a domestic relationship. He found where she was staying. He entered her camper before her. He was inside the camper when Miss Berge entered. When Miss Berge entered, the PSI indicates that he was cutting up, I believe, a blanket that belonged to one of her children, and then the assault began. So all of that conduct was pre-offense conduct. It was him going to the place where she was likely to be, waiting for her to arrive there. People versus Houston says lying in wait is quintessential predatory conduct behavior. So I think the standard for 15 points is met. Even if the court does not agree, I think the standard for scoring OV10 at 5 points is also defensible in this case. The defendant is heavier, he is taller, he is more muscular than Ms. Berge. And for the reasons the court said, the PSI indicates several facts that give rise to a reasonable belief that he exploited those things during the assault. He pile drived her into the floor. He pulled her back into the camper by her pants, ripping the belt loops on her jeans. She was unable to escape of her own volition and her own strength. So I think even if the court rejects predatory conduct, scoring in the PSI is still proper.
Thank you. The attorneys are aware that the scoring is by a preponderance of the evidence, and the court is entitled to consider all record evidence in making its scoring determinations. I have to score the highest amount that I can under the guidelines ranges as long as it's supported by a preponderance. And so the court can look at the PSI, the briefing that's been done by the attorneys in terms of the factual information that's supported from a police report, preliminary examination transcript, and any other record evidence. In this case, the court finds that 15 points is appropriate to score under OV10. The court would note that under People versus Cannon, the prosecutors correctly articulated the standard, and that is I have to find that there was pre-offense conduct. Pre-offense conduct in this case has been developed already as a factual matter, but the court finds by a preponderance of the evidence it's also convincing that there was pre-offense conduct and that the defendant was the person who arrived at the victim's place of abode. It was a camper, and that the victim's description, at least from the PSI, which is in the PSI, is that she was shocked to learn that he was there because she had been in hiding and had been moving her camper on at least one occasion over a period of 5 weeks. She indicated, at least during the preliminary examination, as referenced by the prosecutor, that when she arrived, the defendant was cutting up a blanket. The defendant took issue with that at a prior plea proceeding and described that he could not have cut up the blanket, but the allegations remain. And the allegations speak to the shock that the victim felt in having Mr. Wiesner in the motorhome or the camper at the time. That was pre-offense conduct. The conduct that was ultimately engaged in, which by Mr. Wiesner's own account was holding a broken broom handle and holding it in a way as a dangerous weapon to make Miss Berge feel that she was going to be assaulted, constitute the elements of felonious assault. Even that offense clearly was directed at a specific victim. And the question then becomes whether or not there's vulnerability, and that's the readily apparent susceptibility of the victim to injury, physical restraint, persuasion, or temptation. And with the contextual background in mind that the parties were in a dating relationship, Ms. Berge claimed that she was fleeing from the defendant. Ms. Berge claimed that she was in hiding and that she had moved her camper to try to evade Mr. Wiesner knowing where she was. In a context of the fact that she was then overpowered by the defendant based on Ms. Berge's statements as contained in the PSI, there is clear vulnerability. Ms. Berge was susceptible to injury. She was injured according to her statements to police at preliminary examination and as contained in the PSI. She was strangled, she was choked, she was punched, and she had her jeans ripped when she tried to escape and she had been pulled. Clearly that indicates a difference in size or strength, particularly strength, but it also expresses the victim's own vulnerability to that type of an attack. And the third question is whether or not there was victimization as the offender's primary purpose. Under the circumstances that the court has described, the court can't think of a different purpose for engaging in pre-offense conduct. In other words, if the purpose of the defendant were not to assault, harass, intimidate, threat, or wound Miss Berge, what purpose would he have in going to her residence or her place of abode, the camper, when she had left him 5 weeks ago and had been, in her words, in hiding? So the circumstances, by preponderance of the evidence, again, convinced the court that there was pre-offense conduct that was directed primarily at Ms. Berge and that it was her purpose of attacking her vulnerability. So the court scores OV10 at 15 points. In terms of the next objection, Mr. Horowitz, did you have other objections to the scoring guidelines?
I did not, Your Honor. I have responses to the prosecution.
Sure. I thought you had objected to OV12 as well.
Your Honor, I had asked to score OV12.
Oh, I'm sorry. I'm looking at my briefs backwards. In terms of the prosecutor's responses then or objections, which objections did you have?
Your Honor, I had objections to OV1 and OV12.
That's to OV1.
As to OV1, Your Honor, OV1 is properly scored at 10 where the victim was touched by, quote, any other type of weapon. This is a felonious assault case. The defendant's plea in this case did not encompass him using the weapon or touching Ms. Berge with the weapon, but the court is not bound by simply the factual basis for the plea. The court can look at other facts and circumstances that can be shown by a preponderance. The PSI indicates that the broom was used to strike Ms. Berge. Ms. Berge indicated that it was broken on her back. She also testified to that at the preliminary exam. Given that the plea by necessity defines that broom as the dangerous weapon, and given that there is a preponderance to believe that Ms. Berge was touched by said dangerous weapon, OV1 should be scored at 10 points.
Your response, Mr. Horowitz?
Two things generally. One, the plea was based on threatening with the broom as a dangerous instrument rather than contact. Mr. Ziegler's correct, and I believe Your Honor already referenced that was the basis for the plea. The guidelines statutorily say do not score points on felony assault when for the weapon being merely implied. So you would not score points for the weapon being implied. So the question is whether or not there is evidence of a dangerous weapon being used to make contact. I'd say no. And this is a bit technical, but the weapon that was used, and we are almost stretching to call it a weapon, was
The client admitted under oath that.
Correct. Correct.
There's a factual basis for it being defined as a weapon. Right?
correct.
So we're really
And I'm
not
gonna-
stretching.
And I'm gonna try to navigate around that.
All right.
Was a broom that is, one of those hollow, cheap brooms that you get from Home Depot or Walmart that Mr. Wisner broke over his knee and threatened the defendant with out of anger, right? To find that it was a dangerous instrument or a weapon, I believe your court would have to look at the method or manner in which it was actually
Well,
used.
Mr. Horowitz, if you want to make reasonable arguments, I'll let you, but I'm not going to allow you to make arguments that are contrary to law or to your client's under oath statements. It is and was a dangerous weapon because that's what he pled to and that's what the law requires. If you want to argue that it wasn't used to touch another individual, that's a factual argument that's permissible. That's really what the question is did the weapon touch somebody? It's not a question of whether or not it's a dangerous weapon. It was, we stipulated that it was by offering a plea. Your client told me it was a dangerous weapon. So that fact is settled. The factual question now is there proof in the record that the victim was touched by any type of weapon?
So if I may, I understand your Honor's point, and of course I won't argue your honor. The point that I was trying to make, though, is that whether or not something is a weapon should depend on how it is used. And if I threaten
It is that,
right, and
but you've already conceded by the plea that it is a dangerous weapon. We couldn't be here for a sentencing on a felonious assault if there wasn't already an agreement that it was a felonious assault, which is necessitated by using a dangerous weapon.
correct. I believe that I could threaten somebody with an instrument in a way that makes it a dangerous instrument, and also concurrently use that instrument in a way that was not using it as a dangerous instrument or weapon, right?
Well, this distinction is meaningless though, because the question for OV1 is whether or not a victim was touched with a dangerous weapon. The question isn't about Mr. Wiesner's intent. Well, that's already settled. And it isn't about the legal particularities and whether or not you possess a pen and use it as a dangerous weapon. The question is, was the victim touched with a dangerous weapon? If so, 10 points. If not, no points.
Mr. Wiesner denies touching Miss Berge with the broom. He pleaded to threatening with the broom. He broke this cheap instrument over his knee out of anger and threatened with it. Mr. Wiesner denies hitting Ms. Berge with it. And also, I would note that many of the allegations that are made by Ms. Berge at some point start to ring incredible, as the pile driving, the wrestling moves, the extent of what is alleged is probably exaggerated, in that somebody could not perceive those sorts of wounds and not have physical injuries. Somebody could not execute those maneuvers in the space of this trailer that's just a normal trailer, where you don't have the room to pick somebody up over your head. And if, considering these alleged maneuvers in the context of the prosecution's assertion of this, big strength differential between Mr. Wiesner and Ms. Berge, it just doesn't stand to reason that they could have actually occurred. So
the court notes that the standard is preponderance of the evidence, and the defense has a unqualified ability to challenge as inaccurate factual circumstances. And I'm sure we'll hear that in a moment when we get to factual challenges. But the existence of a legitimate or bona fide dispute about the facts does not mean the court can't make a determination as to a preponderance of the evidence. To the extent Mr. Wiesner decided to have a trial in this case, and he explicitly said he did not want to have a trial in this case, the jury would have had to determine those facts, and the jury would have determined them by proof beyond a reasonable doubt as to whether or not there was a felonious assault or there was the alleged choking offense that was originally charged as a higher offense. That is taken out of the jury's hands, though, and there is no more a standard of proof beyond a reasonable doubt. Instead, the court, as the fact finder, must determine the scoring of the variables. And I have to do that by a preponderance. And when I have two conflicting stories, one, Mr. Wiesner's story, and his story was under his plea that he broke a handle of a broom over his knee and then threatened Miss Berge with it. And I have, on the other hand, a alleged victim, or a confirmed victim now, story that she was hit with that same weapon. The question is whether or not the evidence or the court's conclusions preponderate in one way or the other. In this case, the background of this case also helps the court make that determination. And the background of this case is, in general, the statements that Mr. Wiesner has made, the communications I've had to have with him throughout the case, the very difficult nature of many different prior hearings, and the fact that Mr. Horowitz, I think you're at least the second or perhaps third attorney, there's been problematic communications between the defendant and his attorneys in the past. All of those things enter the court's mind in terms of credibility assessments. And when I have to make a credibility assessment between a victim who says that she was attacked, she was hit with a weapon, which the weapon was a broom, when the PSI indicates and the police reports have indicated that there was a broken broom that was discovered in the camper, and when the defendant, in his own plea, indicated that he did use a broom handle as a weapon, the court finds that the evidence preponderates towards believing the victim over believing the defendant's denials. So if it's a close case, it may be the evidence still preponderates in favor of the fact that Ms. Berge's statements are entitled to belief. And even if they weren't believed by a jury by proof beyond a reasonable doubt, for purposes of a sentencing hearing, I'm convinced by a preponderance of the evidence that the victim was touched by a weapon, and that was the broken broom handle. That's, of course, the scoring is only 1 at 10 points. In terms of the next objection that the prosecution had.
Your Honor, very similarly, OV12. OV12 was scored at 0. OV12 is properly scored at 5, where there was one contemporaneous felonious act against a person that doesn't result in a conviction. In this case, there were 2 felony charges, the felonious assault, which the defendant pled guilty to, and the strangulation was dismissed for very similar reasons, given that Ms. Berge made those statements at the time, given that she testified to them at the preliminary exam, given that the defendant pled guilty for dismissal of that higher offense. I do believe there's a preponderance of evidence, at least, to believe that Miss Berge was strangled and that therefore the defendant did commit a contemporaneous felonious act. Therefore, OV-12 should be scored at 5.
Mr. Horowitz, your response?
Your Honor, again, I don't believe that the record supports a credible determination that everything Ms. Berge said happened. I would also argue that I believe that there's probably that these are all part of the same transaction. They're all part of the same course of conduct, and probably there's some merger issues or double jeopardy issues as to counting the various aspects of this one singular course of conduct as separate offenses. Thank you.
Thank you. So the court notes that for all of the same reasons that I indicated in scoring of OV-1, the court considers the totality of the information that's been provided, including the preliminary examination transcript, including the PSI itself, and including the briefs of each of the attorneys. That's the totality of information the court determines in deciding whether or not there was a contemporaneous felonious criminal act. As the attorneys well know, that by statute means that there was another felonious act that occurred, that was charged, and that will not result in a separate conviction. In this case, the argument for the defense is that that is subsumed in the same events, and the court ultimately disagrees. If the same elements were in place or the same act was resulted in multiple charges, I would tend to agree. But this is many separate different acts or allegations that are involved. And again, by a preponderance of the evidence standard, for the same reasons I found credible the statements of Ms. Berge as contained in the PSI, I find them credible for OV-12. Ms. Berge didn't just claim that Mr. Wiesner had threatened her with a broken broom handle. She testified at the preliminary examination, apparently, and the PSI suggests that what happened was that he broke it over his knee and then hit her with it. She also testified that at previous times there was a struggle from the PSI language itself. The indication from the victim is that she didn't know how Matt found her, and she'd been hiding for 5 weeks. Nobody knew he was there, how she was there, and she moved the camper to this location the day before this happened. As soon as Matthew saw her, he pile drive Rose into the floor and placed her in a chokehold and started punching her in the face. That's the first description. Then later on, she says, when the attack was going on, Matthew heard the homeowner Caleb Gibby. That's when he paused the attack, then broke a broom over Rose's back. That's the contact with the weapon, and fled out of the camper a little after the Caleb, who instructed Rose to go inside the house and call 911. In other words, temporally, it appears that there's a different, although it's an ongoing event that's going on. First, there was Mr. Wiesner's alleged choking, putting his hands over her and putting her in a chokehold, and started punching her in the face. That would be a separate felonious criminal act by preponderance of the evidence of assault by strangulation. Then he broke the handle once he heard Caleb Kitty outside, and then that's when he committed the felonious assault that she ultimately pled guilty to, although he again did not acknowledge touching with the weapon. So the court finds that there is indeed, by a preponderance of the evidence, additional felonious criminal activity that's charged. It did not result and will not result in the conviction. Therefore, 5 points is appropriately scored. Did you have additional objections to the guidelines ranges, Mr. Ziegler?
I do not, Your Honor.
Do you, Mr. Horowitz?
No, Your Honor.
The court's going to count up then the scoring that I have: 10 for OV1, 5 for OV3, 15 for OV10, 12 or 5 for OV12. That would be 35 points total. 35 total points with a Class F crime, PRV level E. 35 would be level 3, making the guidelines range 12 to 24. The attorneys want to be heard on those mathematical calculations.
I agree with that, Your Honor.
No, Your Honor. Based on the court's findings, I believe that calculation is accurate.
All right. In terms of the background of the PSI, Mr. Horowitz, do you have challenges to the background of the PSI, the factual circumstances?
No, Your Honor.
Mr. Ziegler, do you?
No, Your Honor, I just have a typographical correction that the court has already hit on. On page 2 under the description of offense, the witness was named as Caleb Kitty. It should be Caleb Kibby, BBY.
Any objection to that change?
No, Your Honor.
The court will make that change. Elocution on behalf of the people.
Your Honor, Mr. Wiesner is before the court for sentencing on 1 count of felonious assault. This will be his 17th conviction overall. Among those, he has numerous convictions for theft offenses and several assaultive crimes, including an R&O, a domestic, and an assault and battery. His record does not recommend him well to community supervision. In the instant case, he was in a relationship with Ms. Berge. Following that relationship, Ms. Berge apparently went into hiding staying in a camper at a friend's house. She indicates in the PSI, or in the information in the PSI, it indicates that she had moved at least once to try and avoid Mr. Wiesner. Apparently, her fear of Mr. Wiesner was well justified in this case because somehow he managed to locate her, entered her camper without permission, and assaulted her. The assault only ended because Mr. Kibbe noticed a struggle in the camper, and upon seeing Mr. Kibbe, Mr. Wiesner fled the scene. According to the victim's version of events, she was strangled, and the defendant broke a plastic broom across her back. While Ms. Berge historically has not been the most credible or reliable witness in other matters, she did appear at the preliminary exam, and she did testify under oath to those facts in this case. She also had redness and abrasion on her face consistent with the struggle. There was a broken broom consistent with a struggle. That's all in the PSI. Caleb Kibbe also appeared and testified at the preliminary exam, and identified Mr. Wiesner as fleeing from Ms. Berge's camper. All of that is to say that the offense itself, as described by the victim, was fairly serious in nature, Your Honor. While the weapon itself, I would admit, and I think this is what Mr. Horowitz was trying to get at, was probably on the lower end of what might constitute a dangerous weapon. The fear the victim felt, or likely felt, having her camper entered by someone she was trying to get away from and avoid, and then being attacked by that individual, that fear was certainly significant to her, regardless of how dangerous the weapon may have actually been. This was also not a crime of opportunity. It's clear from the facts that the defendant must have sought her out with this purpose in mind, to find her at Mr. Kibbe's property and to find her camper there and to enter her camper there. This was not a chance encounter. With the guidelines of 12 to 24, Your Honor, I think a prison sentence is called for. This would not be the defendant's first prison sanction, and he's had numerous jail sanctions over the years. His history and the severity of the offense do not call for a low-end guideline sentence. If anything, they call for a sentence at the higher end of the guidelines range. Tracking down a specific victim, targeting them for abuse and victimization, with a concerning criminal record to boot, all suggest to me that a higher end sentence is warranted. I also have very little belief that Mr. Wiesner is likely to reform his behavior, given his history. I strongly suspect that when he is released, he will return to the same types of behavior, just as he did from his prior release from prison some years ago, Your Honor. So for all of those reasons, I would ask the court to impose a sentence of 20 months MDOC.
Thank you. Mr. Horowitz on behalf of Mr. Wiesner.
Your Honor, I think the probably most helpful thing to say on behalf of Mr. Wiesner is to actually point to Your Honor's earlier statements today about your prior interactions with Mr. Wiesner and Mr. Wiesner's prior interactions with counsel. That is to say, it was heated, contested, and Mr. Wiesner was quite simply a different person. When I began representing Mr. Wiesner, I didn't have any of those issues. And since I've been in court with Mr. Wiesner, he hasn't had any of those issues. When I first met with Mr. Wiesner, I was struck by the fact that I found him exceptionally sharp and exceptionally well-spoken. It's not because he got a new lawyer that makes the difference. It wasn't that he had Mr. Trevis before that made the difference. His medication has been switched. He has been medicated differently in the jail. That medication has greatly enabled him to conform his actions to what we all find acceptable. He's even keeled. He's able to exercise patience. He's able to listen to allegations against him that probably don't feel good to hear and isn't reacting to them. I mean, he's reacting to them, certainly, but not reacting inappropriately to them. Frankly, he's doing great, I think. And I think looking at the contrast between what the court's seen before and what the court's seen over the last couple of hearings shows that one, he's capable of reform and rehabilitation, but two, that a lot of what he's been going through is a result of intellectual and mental health difficulties, probably long-standing, and that this medication is really necessary. And without it, he just doesn't have the same, I guess, intellectual and mental health opportunities that the rest of us have. So looking at him from before to today, I think is a huge contrast. And I think that recommends that the court should not impose the highest sentence it can. I think the court should consider, especially given the severity or lack thereof of the dangerous instrument involved in the sentencing offense, that the court should consider imposing a sentence of 12 months, a local jail sentence. That said, we acknowledge Mr. Wiesner's record. We acknowledge that it's long. I believe in between Mr. Wiesner's last prison sentence, he had a strong period immediately following that on supervision of succeeding on parole, probation, and was out, I believe, 7 years or something like that. So I think when the stars align and when he gets his medication adjusted correctly, he's totally capable of doing what we need him to do. So with that, I'd recommend the court impose a sentence at the low end of the guidelines. Thank you.
Thank you, Mr. Horowitz. Mr. Wiesner, was there anything you wanted to tell me before I impose sentence today?
Made a mistake and got to deal with it. Oh, don't I know what to say? Other than sorry.
Thank you, Mr. Wiesner. I appreciate that. I appreciate that you understand you made a mistake, and I do take stock of the fact that this situation today, in terms of your reaction to it, is starkly different than you have been in the past. And I credit you for that. That's a circumstance that I frankly didn't expect, because you and I know we've had some history of difficult interactions. And so I credit what your attorneys claimed is that that is a result of a couple of different things. Probably it's taking responsibility, you taking responsibility for the fact that you're here. You took that same responsibility during the plea by acknowledging that you were guilty and wanting to take advantage of that plea agreement and acknowledge it. And you clearly and unambiguously told me you were guilty. I didn't necessarily expect that either. And I say that only because that taking of responsibility is an important factor to the court in assessing what's a fair sentence. In those situations where I find that a defendant isn't taking responsibility, it makes me less likely to think that they're going to be capable of rehabilitation. And so the fact that you are taking responsibility for your wrong actions is somewhat significant to me, because I didn't expect that. I think that it's fair for you as well to contest the factual information, meaning I don't penalize you for contesting the factual information that I ultimately determined, or that you disagree whether or not there was a touching by a victim of a weapon, or that you disagree that there was a strangulation. Those are all fair things for you to disagree with. And you didn't even touch on them. Your attorney did as an advocate for you. I don't hold that against you in any way. Those are important distinctions, and they have an important impact on your sentencing guidelines as well. Your guidelines were 10 to 23. Now they're 12 to 24. So those things matter to me as well. And I don't count those against you. I did find those facts in against your favor, but I don't hold you any ill will because you contested the factual accuracy of those claims. When I look at the background, the most striking thing to me is that you have now your 9th felony conviction as of this conviction and 8 prior misdemeanors. 4 of them prior were assaultive. Those assaultive convictions really only started to happen when I looked through the PSI no later in life. You had a lot of theft-related offenses. I'm not minimizing those, but to the court, the assaultive convictions are the most concerning because they reflect on the seriousness and the danger to the public and that these type of circumstances indicate. And your attorney's right, even though I think it's very serious when you assault somebody with a weapon, touch them with a weapon, by preponderance of the evidence, assault them by strangulation. The severity of the weapon involved, it also is a consideration. It's not a way to minimize the offense, but it's a way to take into account the fact that there are many different types of weapons that can be involved in assault. An assault with a gun is more serious and therefore deserves a stronger punishment than an assault with a different weapon. Again, that's not to say that this assault was not severe. It appears to me to be very severe. So a severe reaction is in order, but I think that severe reaction can also be tempered fairly with your responsibility taking, the fact that you're sorry for making these bad decisions again. And altogether, that points me in the direction that I think I need to be in, which is a sentence within the guidelines range. It happens to be a sentence within the guidelines range of the original guidelines. It wasn't much of a change again. I think an 18-month sentence for this type of an offense for this type of individual is fair in proportion to the circumstances, and that's what the court will issue is an 18-month minimum prison term up to a maximum of 4 years. You do have credit for 191 days that you previously served. The court will order the crime victim assessment of $130, court cost of $325, attorney's fees of $350, and a state cost of $68. Those fines, costs, and assessments are due today. By state law, if you don't pay them within 56 days of today's date, a 20% late fee gets added on. Mr. Wiesner, you do have the ability to ask for leave to appeal. You can go through those appeal rights with your attorney. The top copy you sign just indicate that you got the rights. The bottom 2 copies are yours. If you wish to ask for leave to appeal, fill those out in their entirety and turn them back into the court. Mr. Howard, other than going over the appellate rights with your attorney, with your client, do you have anything further for today?
No, Your Honor, thank you.
Mr. Ziegler, anything else today?
No, Your Honor.
It's been notice of the appeal signing. This is just a. Your Honor, we'd acknowledge receipt of the notice of right to appellate review. Mr. Wiesner signed that, and we're returning that. This is your.
Thank you.
Again. I gotta give these. That's it. What they. Okay.
Thank you.
Thank you, Judge. Appreciate the case. No, that went over a little bit.
That's right. Thank you. The court is next on the record in the matter of People versus David Joseph Beeland. This is filed with 5-5111
Ryan Ziegler on behalf of the people, Your Honor.
Craig W. Elkhart on behalf of Mr. Freeland is assigned me to my right.
Thank you. Are you David Joseph Beeland?
Yes, Your Honor.
Welcome. We're here for a sentencing today. I apologize. I'm running late on my docket. You were sitting through that hearing, so you know why, but I still apologize. I'd like to be more prompt on those matters. Mr. Beeland, did you have enough time to go through your PSI?
Yes, Your Honor.
Need more time to go.
Please, Your Honor.
Who are you, ma'am?
I am his mother.
Ma'am, if you have something, you can hand it to his attorney. His attorney can approach me, but it's not proper for members of the public to simply interject in proceedings. So if you have something, you can give it to the attorney, and the attorney can decide whether or not to present it to me.
Thank you, sir.
Thank you. Mr. Beeland, do you need any more time to go over anything with your attorney before we proceed today?
No, Your Honor.
Mr. Hart, did you need a brief moment to review those letters?
No, Your Honor.
All right. And do you have any corrections, additions, or deletions?
No, Your Honor.
Thank you. The guidelines are accurately
Yes, Your
stated.
Honor.
Mr. Ziegler, do you have corrections, additions, or deletions?
No, Your Honor.
Guidelines are accurately stored.
I do.
Did you want me to consider any letters that were offered or not?
You're welcome to do that. They know under the existing situation that nothing else is going to happen, Mr. Beeland, but I'm happy by this stuff.
Well, I don't take a position. I simply the only point I'm trying to make is I'll only review letters if they're submitted. The prosecutor has a chance to see them and he has a chance to be heard if he objects, and then I'll see them if there's no objection. But hand them to the prosecutor first.
I will, Your Honor.
Or they're just copies of.
Yes, Your Honor.
Sure. You have an objection to be considering that letter?
No, Your Honor.
All right, so after I hear from all the parties and from Mr. Beeland, I'll take into consideration that letter. So you can go ahead with your allocation, Mr. Ziegler.
Thank you, Your Honor. Your Honor, I support the recommendation. I think an extended term of 18 months probation makes sense. Mr. Beeland has demonstrated in the past that he is capable of complying with probation. According to the report, he has attended AA, but has not completed any substance abuse treatment programs. His prior OWIs were relatively recent, with one in 2023 and one in 2018. He's only 30 years of age. I think Mr. Beeland needs a wake-up call, and he needs to get serious about help with his substance abuse issues. He is lucky that to date, as far as I'm aware, he or no one else has been seriously injured in these OWIs, and his punishments for these OWIs have been relatively light. But should his pattern of behavior continue, his guidelines are only going to get worse and worse, and eventually prison is where he's going to end up. If his first two convictions were not enough to make him realize that he needs to take this seriously and to get help or treatment as needed, I am hopeful that this is the moment that he's going to realize that. I'm also hopeful that a brief term of jail will help impress upon him that that behavior needs to change for good. And I still have significant hope that we will not have to see him back in this courtroom again. I would ask the court to adopt all the recommendations in the report, including the 18-month probation, the 30 days jail up front, 480 hours of community service, and a requirement to attend substance abuse treatment at the direction of the agent. Thank you.
Thank you. On behalf of Mr. Beelan.
Mr. Beelan is a very hardworking man. He's a farmer, has 180 head of, 120, I'm sorry, head of cattle, raises crops on their behalf. His family's here with him today. He's been exemplary while out on bond. I don't think that a jail term is necessary for him at all. Certainly, he should have probationary period and continue on that for a period of time.
Mr. Allhart, I don't have any statute.
I know.
I don't have any discretion.
I know you don't.
So I'll let you make any argument that's reasonable and supported by law or an extension of it, but you can't not sentence him to jail. It's required by statute.
Perhaps I didn't make myself clear. I know that.
Okay.
I'm sorry. I thought I made myself clear.
No, and I might have misheard. I just don't want to hear, I can't allow an argument that's not based upon a law, but as long as.
Concur, Your Honor. I concur. He's, so in any event, I understand the court's position. I understand everyone's position, and I know I understand his position. He's a fine young man. He's just got a drinking problem.
Thank you, Mr. Allhart. Mr. Beeland, is there anything that you wanted to tell me before I impose sentence today?
Yes, sir. First, I'd like to apologize and take full responsibility for my actions. My decision to drink and drive was wrong, and I understand I put others at risk. This has given me the opportunity to look at my life and my relationship with alcohol. I've come to accept that I have a drinking problem, and if I want my life to be different, I have to make changes. Since this happened, I've regularly been attending AA and working with a sponsor. In January, I made the move to farm full-time and start my own mechanic business. This has allowed me to help my father and look after my grandmother. My goal is to leave this behind by living differently and making recovery my top priority. I appreciate the opportunity to address the court. Thank you, Your Honor.
Thank you. I'm going to take a moment to read the letter that was presented to me. The court has read the letter by Grace Beeland, and I take that into sincere account when I impose a sentence, Mr. Beeland. I'm glad to hear that you have apparently changed a lot since this event. In this case of getting old, sometimes that happens. Cases just take time to process through the system. This event was on May 25th of 2025, so it's been over a year since the event. I don't always hear about problems that people have while they're on bond, but I generally do. And my impression is firm that if you were being a problem on bonds to police or prosecutors, I would have heard about it and I would have had to address it. So I credit you for the fact that I haven't heard of any of those things. It appears that you've been taking the bond orders seriously. It's not always the case. Because of that, I firmly expect you're going to take all the probation agent's orders just as seriously. They are part of the basis why I think it's fair to overall adopt the recommendation in this case. State law mandates for a third offense operating while intoxicated that you are sentenced to 30 days in jail. There's only one exception that I'm aware of. That's if you were in a certified treatment or sobriety court program, and then I can suspend it if you were successful in completing it. The circumstances, though, I tend to agree with the prosecutor that even without that mandate, and it is a mandate, meaning I can't disobey it, these circumstances also need, I think, some reminder. I think the prosecutor stated it correctly, a wake-up call. your prior history is only limited to drinking and driving offenses. And it sounds like since this event, through your mom's statement, you are a much better person and in a better position now, working full time, helping your family. And you're doing everything that you can with AA and having a sponsor to recover from the position that you were in, which is driving while you're intoxicated. I have to look at the scale of those events and determining a proper punishment. And the scale here is on the lower end. That does not mean it wasn't dangerous. It was, and you acknowledge that already. But on the scale of what I see in drunk driving offenses, this is on the lower end. And that's certainly something I also take into account as positive. And it's the reason why I think the state statutory minimum is enough in this case, particularly because I'm also putting you on probation and I want to monitor how well you're doing. And I am going to order that when directed by your field agent, you must engage in whatever treatment they believe is necessary given the circumstances of your recovery and how it's ongoing. They may, in their discretion, not suggest that you do anything additional, and that's fine, but they're going to know you better because they're going to be meeting with you at whatever schedule they dictate. So the court will follow that recommendation of putting you on probation for 18 months. Under the circumstances, if you show positive strides, pay fines and costs in full, I don't have any issue with you being released early from probation. If this is an offense that you can be released early from probation, but I want to have that time period to make sure everything continues to go good. I will order that you pay the fines and costs as were indicated, which include a $130 crime victim assessment. You have to pay $30 per month supervision fee when you're on supervision. You'll pay court costs of $325, a state mandatory minimum fine of $500, DNA testing fee of $60, and a $68 state cost. By state law, those fines, costs, and assessments are due today, and if you don't pay them within 56 days of today's date, a 20% late fee gets added on. I will impose the 30 days in jail that I'm state mandated to order. You do have credit for 5 days that you previously served, and as soon as you're done with that, you'll be released. You need to meet with probation to sign that probation order. I hope that your recovery continues to go well for you. Your family certainly would benefit from it, and obviously you would as well. Good luck.
Thank you, Your Honor.
Thank you, Your Honor.
Also, I also need to advise you, Mr. Gill, you do have the ability to ask for leave to appeal. Your attorney can go through those appeal rights with you. You'll just sign the top copy to indicate that you got the rights, and the bottom 2 copies are yours. Anything else, counsel?
No, Your Honor. Thank you.
No, Your Honor.
Thank you. Is Mr. Taylor here? Ready, Mr. Pettis? Thank you. Is Mr. I don't see that Mr. Travis is here. Is Mr. Travis outside? Do you know, counsel, meeting with an attorney?
Went back to the.
I think Taylor's in person. I can see him.
Is Mr. Taylor next door? This. The court will call next the matter of Peter versus Rodney Matthew Taylor. This is file number 26-5175FH.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Taylor, Your Honor.
Thank you, sir. You're Rodney Matthew Taylor.
Yes, I am, sir.
Mr. Taylor, thank you for your patience. I'm behind on my docket and I don't like to be that way. Have you had a chance to review the PSM in this case?
I did, Your Honor.
Do you need more time to review it?
I do not.
And on behalf of the defense, do you have any corrections, additions, or deletions, Mr. Travis?
Not to the report, Your Honor. We
Just all your objections to the scoring guidelines, and that's the next question. And in terms of the objections, it looked like you had filed the objection and then the department had agreed with your objection. Was that accurate?
That's correct, Your Honor.
And do the people agree with the objection as well?
I do, Your Honor.
So the court will fix the scoring of the guidelines. I had a chance to review the objection. I independently looked at it and it appears to be an accurate objection. And so that would be the proper spot. PRV 1 should be 0 instead of 25. PRV 6 should be 10 and PRV 7 should be 10, correct?
correct.
Is that a total amount of, it looks like 25, then the guidelines would remain unchanged, no, correct?
That is correct also.
Is that correct, Mr. Ziegler?
Yes, Your Honor.
All right. Any other corrections, additions, deletions, or objections?
Not from the defense.
So do people have any objections to the guidelines now as they're scored?
No, Your Honor.
Do you believe the guide, or excuse me, do you have any other corrections, additions, or deletions?
None.
Should we have people then?
Your Honor, Mr. Taylor's before the court having been caught possessing methamphetamine while on 7411 probation for also possessing methamphetamine. Clearly, a probationary sentence at this stage makes little sense. Judge Mertz has already revoked his 7411 status and gave him either 90 or 98 days that he had held in abeyance over him. I believe he's still serving that sentence. I don't think that's a sufficient punishment in this case, Your Honor. That was his punishment for failing 7411 probation. It was not necessarily his punishment for new criminal conduct of possessing methamphetamine, even though they're one and the same act. I think the fact that he was possessing methamphetamine needs to be punished by this court in and of itself, not just the 90 days that Judge Mertz had held in abeyance in case he violated his probation in any way, shape, or form. His guidelines are 0 to 11. He has relatively minimal criminal history, but there's little else in the way of mitigating circumstances, in my view, when someone violates probation by doing the very same thing probation for. Moreover, it was within a few months of being sentenced to 7411 that he committed this offense. For those reasons, Your Honor, I think a sentence in the middle of the guidelines is probably appropriate. I would ask the court to give Mr. Taylor 6 months with credit for any time he has served.
You have information as to when the 7411 revocation and sentence.
I do, Your Honor. There was a probation violation hearing on June 2nd, and I believe either 90 or 98 days were imposed. My notes say 90, but I think the order said 98.
Was that on June 2nd?
It was, Your Honor.
Do you have any reason to dispute the June 2nd sentencing date, Mr. Travis?
I don't, Your Honor.
And the reason the attorneys make census I'm asking is if that's accurate, we need to update the jail credit days in this case. Do we not? Jail credit was initially calculated up until the date of this sentencing, July 7th, but he would not be entitled to jail credit after his sentence was imposed on Judge Mertz's file, correct?
Well, I would disagree with Mr. Ziegler about how that happened. My understanding was at the time he sentenced him, he had already served those 90. If we even look at the credit, he had already served that time and was given credit for the time he had served, and there was no further jail beyond that
You
point.
think he was given whatever sentence with credit for the amount of time that he had?
That is my understanding of how it occurred, and at that point, he already had the 90 days.
What's your view on that?
That may be accurate, Your Honor, and my notes don't reflect what happened after the sentence was imposed, whether he was given the credit and released or whether he continues to serve it. I only note that he's in custody now. I guess I assume that's because he's unable to post bond in this case.
Well, and if that's the case, then I don't need to change the jail credit. I just wanted to make sure I don't need to change it, and I'm not going to change it unless I hear more information. Did you have any more information for me to see?
I don't, Your Honor. If I find that that's not the case, I can file something to correct his credit.
All right. And on behalf of Mr. Taylor.
Thank you, Your Honor. Your Honor, as we kind of went through, Mr. Taylor just recently pled to his first narcotics conviction. Unfortunately, he is here on this case. He lost the 7411 on that case. He now has, as we also discussed with the guidelines scoring correction, a felony conviction for possession of methamphetamine. He's here before Your Honor to be sentenced on a possession of a controlled substance, but again, in that case, he was possessing methamphetamine. Mr. Taylor has not had a great mid-50s or past 2-3 years. He, at one point had, I think, a pretty stable life. He was married with children. He was employed. It does appear after his marriage fell apart, things have really just not been going quite so well for him. Unfortunately, he had developed a meth problem. He took the 7411, seemingly was complying with that for some time, but he was relapsing and using methamphetamine. That's why he's here. I don't know that he got the seriousness of things the first time around. I think it's pretty clear he didn't. At this point, Your Honor, he's got a jail credit of 138 days. That's approaching 5 months of incarceration. And I can tell you in talking with him, it's had quite an effect on him. One of the comments in here is his attitude and some statements he's made about other folks in the jail. He has suffered a lot of, I guess I'd say, bullying and mistreatment, and he's struggled with complying with being a good inmate and complying with the rules there, or standing up for himself from the bullying. Luckily and thankfully, and I think because he's trying to be an adult and do the right thing, he hasn't been getting in fights. But he's struggled mightily emotionally of how to deal with that, how to deal with folks who say horrible things to him and harass him and basically make the jail a miserable experience. And I have to say, even though he expressed some, outward hostility towards his cellmates, he's not been acting on that. But I know he's been struggling with how to appropriately handle that situation. And unfortunately, in a jail situation, it's not the right thing to do. But a lot of people would just resort to violence. And as much as he's expressed a desire to respond that way, he hasn't, which I think shows some maturity and appropriately doing things. The other things that he's done is he's got involved with NA in the jail. Him and I have talked a number of times. He's, along with just it being personally a negative situation, he's cleaned out, he's reflected, and he'll be able to tell you more about that. And he's acknowledged to me personally that he was not there the first time around. But he wants to get back on his feet. He wants to get the kind of just nice, normal life that he once had back. And he knows that using drugs is not going to work. He knows that it's not no big deal, that it is a problem, and that if he uses substances, he's going to end up back in front of your honor, back in front of another judge, and back in the county jail. And I can definitely tell you, he does not want to be back in the county jail. It has not been a fun time for him. But he has taken advantage. He is going to NA. He's motivated to continue those type of activities. He understands the concept that it's not something he can do on his own now. He understands that he does need help to stay clean. And most importantly, I think he truly wants that to happen because he had a better life and he wants that back. Thank you, Your Honor.
Thank you. Mr. Taylor, was there anything you wanted to tell me before I impose sentence today?
Yes, Your Honor. My life was going spiraling down. I went through a nasty divorce. Ended up on the wrong road. This jail stay has opened my eyes, and old dogs do learn new tricks. And I want to be on the road of sobriety. I want to be back out in the world working, spending time with my family. My youngest daughter is going to make me a grandpa here shortly. I've learned my lesson, and I just want to thank you for your time.
Thank you, Mr. Taylor. I'm glad to hear you have a positive outlook. You sound and present well. You don't look to me to be an individual who's actively using. And I say that not being trying to be coy. I'm aware that in certain situations in jails and prisons, there is access to controlled substances or alcohol,
Right.
and people find it. And so I say that being serious, that it appears that you're treating this matter seriously. It was clear, and again, I'm not saying this to hound on it, but it was clear that you didn't treat Judge Mertz's probationary term seriously.
I didn't, Your Honor. I didn't.
And so sometimes, unfortunately, that's the way that addiction works, is it takes a couple of times for somebody to realize the situation they're putting themselves in. And I hope that's the situation you're in now. That's what you're saying, and that's what it appears clear. You're probably sick of being in a situation where somebody else is telling you what you can do or where you need to go. And having that benefit, hopefully will change your outlook and your activities in the future. You've still got some ongoing matters. According to the PSI, still have some pending weapons and ammo matters going on in Charlevoix.
I do, Your Honor.
I didn't know, and now I know. It's clear that you were sentenced by Judge Mertz. I didn't know what was happening, and I didn't know which judge had you on 7411 probation. So there's still some things you need to clean up. This type of circumstance is not the worst crime I've ever seen. It's an addictive crime, and it didn't appear that it was anything other than just that, your own personal destructive nature of the addiction. And I don't think that top end of the guidelines is necessary in those types of circumstances. I do think that the prosecutor's right. A message being sent that when you're on felony probation for a drug offense and you commit a new felony drug offense, there needs to be a message sent. But I'm confident that that message has been sent and received, and that the punishment that I'm going to indicate is going to be fairly minimal compared with what you could face if you continue down this road. And I think you know that as well. I'm hopeful that you continue doing well. The court will sentence you to the middle of the guidelines, 6 months. It's a little bit more than the exact middle, 6 months in the county jail. You do have credit for 138 days that you previously served. All other than that, assessed costs, including a crime victim assessment of $130, court costs of $325, attorney fee reimbursement of $350, a DNA testing fee of $60, and a $68 state cost. Those fines, costs, and assessments by state law are all due today. If you don't pay them within 56 days of today's date, a 20% late fee gets added on. I'm not otherwise going to order any probation under the circumstances. It doesn't make much sense right now. I hope we get back on the right track, Mr. Taylor, and then we'll see each other in the context of the courtroom again.
Thank you, Your Honor.
You have the ability to ask the Court of Appeals for leave to appeal, so you can go through the appeal rights with your attorney. If you wish to ask for leave to appeal, fill out the forms in their entirety. Thank you. All right, Mr. Seeger, are you ready on Ms. Stout when she can be brought in?
Your Honor, I think she's holding.
Yes.
Yeah.
All right, once we can bring her in, are you ready to proceed?
Yes. I was just waiting for her to be brought up. Originally, I think that they also were holding, so I'm not sure what
Oh, all right.
further off with.
Our next call is a matter of People versus Randy Christine Stout. This is found for 24-4972
Brian Ziegler on behalf of the people.
Thomas Seeger, appearing with on behalf of the Scout.
Thank you. Ma'am, are you Randy Christine Stout?
Yes.
We're here for sentencing today. Did you have enough time to go through the PSI with your attorney?
Yeah.
Enough time to go over it?
No, sir.
Mr. Seeger, do you have corrections, additions, or deletions?
I do not, Your Honor.
The guidelines are accurate.
I do.
Mr. Ziegler, do you have corrections, additions, or deletions?
No, Your Honor.
Do you believe the guidelines are accurate?
Your Honor, the court had addressed at the last hearing the scoring of OV-19 and said that we should be prepared to address OV-19 at 15 points.
You should.
I agree that OV-19 is properly scored at 15 points based on the court's comments at the last hearing and based on the history of the case.
Okay, 10 points, you mean? So my understanding is 10
I'm sorry, Your Honor.
scored for the interference or attempted interference with the administration of justice here absconding for over a year. 15 points would only be if there was danger to a penal institution.
Correct. Yes, 10 points, Your Honor.
Mr. Seeger, did you wish to be heard on the scoring of OV-19?
Your Honor, I would agree that just, I would ask if there is a case that specifically addresses it, then I would ask the court to cite the case if it's going to change it. However, just as a rudimentary reading of it related to other cases that are somewhat similar in nature, I would generally agree that probably 10 points can be scored. It would change the range from 0 to 17 to 2 to 17.
So the court notes that OV-19 is scored when I find that there's interference with or attempted interference with the administration of justice. There's not just one case, Mr. Seeger, there's literally dozens in the Court of Appeals and the Michigan Supreme Court, which have found that a party's absconding for any amount of time is in itself attempting to interfere with the administration of justice. The administration of justice is the court being able to impose sentence on a felony offense that the defendant pled to. Here, the defendant pled guilty to a felonious offense, and it was set for sentencing, and then she failed to appear. Bench warrant was issued 2/5 of 25, and she absconded and failed to allow the court to administer its justice, its business, for a year and 3 months. So I'm not citing any specific case. I'm citing the proposition that absconding for well over a year is the exact definition of the statutory terms of interfering with or attempting to interfere with the administration of justice. There are many cases which support that, but the court's not required to cite cases in support of its rulings. It's entirely appropriate to simply rely on the factual assertions that are contained within the PSI or that are known to the court. So OV-19 is scored at 10 points, and therefore it is a 2 to 17 guidelines range because the OV level does jump up to 2 with 10 points total. In terms of the background of the PSI, did the attorneys, either one of the other attorneys, have any corrections, additions, or deletions?
No, Your Honor.
Yes, sir. Mr. Ziegler, did you have elocution?
Your Honor, Ms. Stout has done herself no favors in this case. In 2024, she had 2 cases for possessing narcotics. She pled guilty to this one in January of 2025. The people did not pursue the other one. Instead of appearing for sentencing and, in my view, likely getting a probationary sentence or maybe a brief jail term, Ms. Stout decided to abscond until May 24th, 2026. On that date, she was caught in a vehicle with almost 2 ounces of methamphetamine and paraphernalia in her vicinity. According to that police report, she told Sergeant Schaub that the meth belonged to her. While I appreciate her honesty in that case, her behavior in skipping out on sentencing for almost a year and a half, while clearly still engaging in possessing controlled substances in significant quantities, cannot get a pass. Her guidelines are 2 to 17, which are an intermediate sanction cell. There is a presumption on an intermediate sanction cell of no jail, but that presumption can be overcome, and I think is clearly overcome in this case. The defendant clearly has no respect for the law or for the authority of the court and has chosen to ignore her sentencing date and to continue to allegedly violate the law. If she then were to insist on hiding behind the presumption of no jail, I think that would make a farce of the criminal justice system. The defendant needs a harsh penalty for violating the law and then skipping out on the consequences of violating the law. A sentence at the very top end of the guidelines is warranted to send a message to her and to others now and in the future. Appearing at sentencing is not optional. Thank you.
Thank you. Mr. Seeger, on behalf of Ms. Stout.
Your Honor, I would likewise agree that appearing at sentencing is not an optional consideration for any client or any attorney or anyone else that's ordered to appear when they're ordered to appear. Be that as it may, Your Honor, the explanation is that Ms. Stout was dealing with a very significant substance abuse problem. And in as much as it's easy for us to say, well, there's a piece of paper that says that you need to appear on a certain date, or there's a piece of paper that tells you that you need to immediately discontinue using substances because it's a condition of your bond, is not entirely realistic. The part about showing up when you're required to is definitely realistic, but the order related to conditions of bond saying you need to comply with the conditions of your bond and no longer use drugs when you've been using them for an extended period of time, and you clearly need to be entered into some kind of treatment, is not probably particularly reasonable. It's reasonable to order it. It's probably not particularly realistic that somebody is going to be able to discontinue a substance abuse problem that they have had for an extended period of time. And I think for Ms. Stout, there came a point wherein she continued to struggle with her substance abuse problem. She was unable to turn herself in during that time period because it would have been difficult for her to detox during that time period. She was trying to address many of the other personal issues she had together with her own substance abuse problems. I don't use it as an excuse, Your Honor, because clearly it's not an excuse, but it's just rather it's an explanation. Mr. Ziegler had referenced that when she was apprehended, she was in possession of certain other prohibited items. That matter is set for trial, and we're likely to have a trial absent there being a resolution. To the extent that the court wants to take that into consideration at a later date following trial, I guess the court can take that into consideration, but I would not ask the court to take that into consideration in advance of trial because there's not been even a preponderance of evidence determined, at least as it relates to the other factual allegations and its conduct that will be judged at a later date, either by resolution if she enters into a plea or by trial if she's either acquitted or convicted of something. I don't find Ms. Stout to generally be a bad person. I find her to be a person who has struggled with substance abuse. She expressed to me that she wants to remain clean, she wants to remain sober, that she wants to get into treatment if that were a possible option. But I think, like many people, she was just struggling through life. And unfortunately for her, as opposed to perhaps members of the court or other people who have more standard living or have more standard occupations, it's easier for somebody who is in a position where they don't have substance abuse problems or they don't have financial issues to cast stones about, well, you should do this or you should have done that when we're not living their life, because I don't have to worry about where my next meal is going to come from, and I don't have to worry about paying my light bill or how I'm going to get to a substance abuse treatment facility or where I'm going to live the next day. I have those opportunities. And it's not to say that Ms. Stout does not have other opportunities to try and rectify her ship, but I think that circumstance in life has been different based on the people that she's been associated with for years, based on her own living standards, and perhaps based on many of the choices that she once made that became addictions for her in later years. In any event, Your Honor, she understands that the court is likely to impose sentence. She understands that the court was not pleased that she failed to appear for sentencing. She's just asking the court to impose a sentence within the guidelines, and she's hopeful that the court will allow her to get into treatment at some point in time, which would be in everyone's best interest, including the general public. And as much as I do understand that the court has to send a message, but also one of those messages may be that the court is not always entirely harsh and not looking to destroy people's lives. It's also looking to allow people to address the problems that brought them into court in the first place, because I don't generally want to see my clients again, other than to maybe run into them somewhere in town and say hello. But I clearly don't want to run into Ms. Stout again dealing with another drug file because it continues to have a problem. If people don't take advantage of that programming, if they're afforded opportunities and they don't do particularly well, that's somewhat on them, but I still want to give them the opportunity because I don't want to give up on people who are making choices that are not, at least in my mind, malum se, they're malum prohibitum. They're something that they shouldn't be doing or they're prohibited from doing by statute, are not inherently wrong. And although I continue to think that using drugs is an entirely bad life choice, it's not my life to make decisions for them. And that is implicit in the idea of liberty. In any event, Your Honor, she's just hopeful that the court will give her a reasonable sentence, and at some point in time, whenever that may be, will allow her to get into drug treatment, which I think is in everyone's best interest.
Thank you. Ms. Stout, was there anything you wanted to tell me before I impose sentence?
I know I absconded for bond, and I know that wasn't right. I shouldn't have. I wasn't in my right mind. But yeah, everything Steve said, I would just like the opportunity to prove, I guess, the law different, and I have a good support system. But yeah.
What arrangements have you made for treatment?
Well, because of the other case going on right now, I thought I had to be sentenced on both cases before I could get into treatment. Otherwise, I would have already started the progress.
So you haven't made any arrangements?
No, because they told me I have to have 45 days, and then I'd have to redo the intake again for treatment. So I was waiting till this other case because a lot of people were telling me that I couldn't go.
Ms. Stout, I've taken a chance to review the entirety of the PSI. I'm obviously familiar with this case. I presided over it. To be clear, I take no personal affront to the fact that you absconded for over a year. It's a factor that I have to consider, however, and it's a factor that does you no benefit. It does you much harm. So the fact that that happens does not mean the court has a personal affront about the circumstances. You're entitled to do whatever you want, but you need to also bear in mind that what you do has then actions and consequences. The consequences for not only fleeing the jurisdiction of the court for over a year, but then being caught with 2 ounces of methamphetamine apparently and telling the police that you possessed it and owned it. And while I do consider those things, I'm entitled to consider all of those things because they're part and parcel of how you got back into the court jurisdiction. So any argument suggesting that the court shouldn't take that into account is disregarded by the court. It is accurate that you're entitled to a trial on that in terms of a different preponderance, a different standard of evidence, proof beyond a reasonable doubt regarding whatever you're charged with. But that's not the standard I'm dealing with here. What I'm dealing with is a preponderance of the evidence. And I know from getting a booking sheet that said you were arrested, and I know by preponderance of the evidence from what the prosecutor claims, and he has access to police reports that I don't, that there are circumstances which convince me that you were in violation of the law at the time you were arrested on this offense, and being in violation of the law by allegedly possessing with intent to deliver meth. That's also contained in the PSI. At the time you were arrested, you had 2 outstanding bench warrants, one in Roscommon, one in Kalkaska, for the delivery of meth or possession with intent to deliver. All of that is not only fair for me to take into account. If I didn't take it into account, it would be a significant error because I have to take into account everything that's in a PSI, everything that's in your favor and everything that's not. Would you have appeared at the sentencing hearing back in February of 2025? It would have been very likely that you served less than probably 47 days in jail that you've already served in this offense up to this date. But that's not the circumstance that we're in now because you were outside of the court's jurisdiction. That enhanced your guidelines range from 0 to 17 to 2 to 17. And you were over a year absconding and you picked up new charges. New criminal behavior, absconding. You weren't charged with that, at least that I know of yet, but you certainly could have been charged with absconding. A 34-year-old being sentenced on a 3rd felony, 4th prior misdemeanor, 4 prior misdemeanors, is a circumstance where really straight jail is the only reasonable answer, and a lot of jail because of the circumstances. Again, I don't have on this record anything to suggest other than your attorney's words that you are serious about getting into treatment or changing your personality or your background with addiction. Perhaps you are, but I haven't heard it. And so I don't take that into account as a significant positive impact or a positive rehabilitative potential. Perhaps it's there, but it's not been explained to me in any way. And so with that backdrop, I think a 10-month jail sentence is important. It's important to send a message to you. There's punitive actions and there's repercussions for when you fail to appear. It's also still within the guideline sentence. And any presumption, as the prosecutor articulated, that there is for a non-jail sentence has been thoroughly rebutted by your actions. In this case, of absconding bond, of committing new criminal offenses, of having bench warrants, and otherwise being only 34 years old, being sentenced today on your third felony. So for those reasons, a 10-month jail sentence is imposed, credit for 47 days that you previously served. Crime victim assessment will be assessed at $130. Court costs of $325, attorney's fees of $350, and the $68 state cost. By state law, those fines, costs, and assessments are due today. If you don't pay them within 56 days of the date, this is 100% on. If you have the ability to ask for leave to appeal, you can sign the appeal rights, fill out the copies, and turn them into the court if you wish to ask for leave to appeal.
And Your Honor, just for the record, she's executing a copy of her rights. No, give it to Caleb.
Thank you.
That's now. So,
I'll leave them.
Our next call is a matter of People versus Kendra Marie Hiddle. This is file number 26-5192 FC and 26-5162 FC and 5163 FC.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger, pen with my behalf, Ms. Hiddle.
Thank you. Are you Kendra Marie Hiddle?
Yes, sir.
Ms. Hiddle, we're here for a sentencing today. Did you have enough time to go through the PSI?
Yes.
Do you need more time?
No.
Mr. Seeger, do you have corrections, additions, or deletions?
No, Your Honor.
Do you believe the guidelines were accurately scored in each offense?
I do, Your Honor.
Mr. Ziegler, do you have any corrections, additions, or deletions?
No, Your Honor.
Believe the guidelines are accurate?
I do.
As I read through the PSI, gentlemen, I want to make sure the attorneys have a chance to point this out before I make a determination or to make argument on it. There seemed to be a suggestion that you had advised, prosecutor's office advised that there may be consecutive sentencing, which is applicable. The way I read the PSI, it seemed to be that the one offense she was charged with, it may have been a situation, I want to ask for clarification, that you waited for a lab result before you charged, and then she was arrested on the outstanding warrant at the time she was arrested for the second offense, the resisted obstructive offense. So is that factually how you think it happened?
Yes, Your Honor, I do agree that consecutive sentencing does not apply. I did not speak directly with the author of this report. I may have said in passing to someone at MDOC that I had thought consecutive sentencing might apply. But in reviewing the facts of the case, she was arraigned on the same day on both of these matters.
All right, and that's how I read it, but I wanted to make sure I wasn't missing something. Mr. Seeger, do you agree under these circumstances, consecutive sentencing is not applicable?
Yes, we were going to address it during the course of sentencing if it became relevant, but yes.
And I agree, again, based upon the facts that are outlined in the PSI. Anything else on behalf of the people regarding the PSI background?
By way of addition, deletion, or correction, no, Your Honor.
Any corrections, additions, or deletions other than that, Mr. Seeger?
No, sir.
All right, elocution on behalf of the people.
Your Honor, I appreciate the recommendation of probation and parole in this case, but I do not agree. Ms. Hiddle is well deserving of prison in these matters. She's before the court for 2 felony convictions for R&O and possession of methamphetamine. There's also a misdemeanor case where she fraudulently scanned bottle return slips multiple times to the tune of $357.70. That's been rolled into this global resolution of her files without additional conviction. That restitution is part and parcel of the PSI.
That's the 35770.
Correct, yes. These are her 24th and 25th convictions by my count. She's only 40 years of age. She has had, by my count, 12 prior jail sentences in her life. I cannot agree with the implication inherent in the recommendation that a 13th jail sentence is likely to lead to rehabilitation or to send a strong deterrent message to the offender or to the community. On the contrary, it seems to send the message that you can continue to reoffend repeatedly, and local time is the only consequence that you're likely to get. Looking at the defendant's history, past the history to the offenses themselves in this case, they also suggest to me a prison sanction is warranted. In the first file, the possession of meth, she was pushing an empty stroller around midnight. Police were called due to the suspicious nature of that behavior. She was found to be in possession of multiple pipes, syringes, and baggies. When Sergeant Beaver saw a pipe in her hand and asked her about it, instead of handing it to the officer, she threw it into a field where it was never recovered. The other paraphernalia that was subsequently found did test positive for methamphetamine. In the second file, Kendra and Ryan Hill were spotted by law enforcement, where they knew that Miss Hill at least had a warrant for the prior incident already outstanding. While law enforcement was focused on Ryan Hill, Kendra ran off across the street into a separate private business and locked herself in a bathroom in that business. She did not come out despite law enforcement's repeated commands to that effect. Law enforcement had to locate an employee, get a key to the bathroom, and when they entered, they found Kendra kneeling by the toilet, apparently attempting to flush suspected contraband down the toilet. Both of these offenses involve blatant obstruction of justice. Both involve suspected possession of controlled substances. Both involve tampering or destroying evidence. These offenses are not atypical for Ms. Hill, with her record containing a prior attempted R&O from 2010, for which she got a 3-month jail sentence. She also has prior drug offenses, ignoring the alcohol-related ones. She has a possession of analogs from 2010, 6 months jail on that. A possession of marijuana in 2014, 90 days jail on that. With the guidelines of 5 to 23, this court should not allow Ms. Hill to continue to do local time sanctions when it is abundantly clear she will not and cannot learn anything from those punishments. The definition of insanity is doing the same thing over and over and expecting different results. 12 jail sanctions, including 3 for drugs and obstruction, have not deterred her one iota. Before the clock strikes 13 on these jail sanctions, it's time to try some harsher medicine. At best, it may deter her from committing further crimes, although I doubt it. But at worst, at least she will be physically unable to continue her pattern of drug theft and obstruction crimes for an appreciable period, and it may help deter other offenders who would otherwise get the message that repeatedly obstructing the police is worth the risk if these are the likely consequences. A sentence of 20 months is more than justified on the primary offense, Your Honor, and that's what I would ask the court to impose, or at least a prison sanction of some stripe. Thank you.
Thank you. On behalf of Ms. Hill.
By way of allocation, the only thing that I can say is I don't disagree, and I've known Ms. Hill and I've represented Ms. Hill quite a few times over the course of her lifetime. And
Mr. Seeger, you need to speak up.
Sure, yeah, I'm saying. Your Honor, I've represented Ms. Hill quite a few times during the course of my legal career. I've represented family members. I recognize that she struggles with substance abuse. It has caused a lot of problems for her. Historically, it has caused a lot of problems in her lifetime. She has constantly struggled with substance abuse problems, either by her own choice or by virtue of being involved with other people who are using similar like substances. But through it all, Your Honor, she generally has tried to change her behavior. Clearly, she continues to have a drug problem. I don't see any benefit to sending people to prison unless we're specifically saying that they were dealing drugs in some meaningful capacity, which is not the allegation here, Your Honor. She's alleged to have been in possession. I shouldn't say alleged because she pled to it. She pled guilty to possessing drugs, Your Honor. She didn't plead guilty to selling drugs of any commodity. And I agree with Mr. Ziegler that there are usually elevated penalties for people who continue to come back to court. But in this particular instance, Your Honor, I can't say that it benefits anyone, because whether you gave her jail time, you gave her probation, or you sent her to prison, Mr. Ziegler hit the nail on the head. He can't even specifically tell the court that it is somehow going to change her thought process in terms of not using drugs or her ability not to use drugs, because it's really only self-destructive behavior for herself, Your Honor. She's not a danger to the public per se. And I understand that there's this allegation that she was tampering with evidence. And that's great that Mr. Ziegler points that out, but there was no pipe that was recovered. So we don't know what evidence that was. So I don't know how far she threw it.
So she successfully tampered with evidence.
Okay, well, I'm just saying, I'm just playing off of what you said, Your Honor. And when they find her in the bathroom, they didn't find any similar like items in the bathroom. So we're making the allegations, and the court may even find by preponderance of the evidence that those items are true. I'm just merely saying that I don't see any benefit to sending her to prison because no lesson is learned there, Your Honor. Really, what we should be leaned at is trying to assist her in getting some kind of rehabilitation. But because clearly going to jail, as Mr. Ziegler pointed out, has not necessarily changed her choices or addiction. Really what she needs to focus on is getting into treatment of some sort, which she's indicated she wishes to get involved with treatment, which maybe she will, maybe she won't, Your Honor, but going to prison is not going to improve her life or her children's life in any particular way. She recognizes that she's got to make changes. She has good family support, at least from her mother. She's been a long-standing member of the community. Whether she does jail time, whether she does probation, whether she goes to prison, she's likely to come back to the community. And the only way that we're going to stop the cycle is by allowing her to get into treatment, some kind of meaningful treatment, as opposed to just sending her to prison. Because I don't really see what that cures in any way, Your Honor. So she goes to prison for a period of time and then she comes back. Well, okay, she's either going to use drugs or she's not. She's not going to have the tools. I've never seen anybody go to jail and or prison and come out a better person, you know, because when they went in there, they didn't have anything. And now when they come out, they have even less. So I really struggle with the idea of sending her to prison. I also somewhat struggle with the idea of probation because I don't necessarily disagree that probation may not be the best feature for her. And maybe if the court was going to give her a sentence, it would be a straight jail sentence with the ability to get into treatment at some point in time, whenever the court deems that to be, fair and reasonable. The guidelines are 10 to 23, maybe somewhere towards the end, wherein she can at least she's served an appreciable period of time already up until today's date. Maybe she can get into treatment immediately. I would much rather somebody use their time wisely as opposed to just idly sit in jail. The idea that, the general public receives a message from somebody serving jail time is absurd. And it's absurd because I don't know how many drug cases were on your docket today, Your Honor, but none of those people seem to have gotten the message, right? No matter what it was that the court did. Because when people have an addiction, they're not thinking about whether or not they're going to go to jail or whether or not they're going to go to prison. They're letting their addiction make choices that they otherwise probably wouldn't make if they maybe had the tools. And maybe they would still make the same decisions, Your Honor. But hopefully, with some tools, with some treatment, she's able to curb what will probably be a lifetime addiction for her. But at least she'll have some tools to address those things going forward. And speaking with Ms. Hiddle, she's just hopeful that the court will not impose a prison sentence. She's hopeful that the court will allow her to get into treatment. She did wish to speak on her own behalf in advance of sentencing.
Ms. Hiddle, was there anything you wanted to tell me before I impose sentence today?
Yes, I'm sorry being brought before you on these charges that have been committed. Being in jail has opened my eyes and I realize this is not the life I want to live. I've hit rock bottom since being in jail. See everyone that I've hurt and let down. My kids. Since my dad died, he was my best friend. My life went on a downward spiral. Couldn't live with him being gone. I have let my kids down and they just want their mom back. I have a good support system. I have 3 amazing kids I'm ready to get back to and be their mom. I accept full responsibility for my actions and just ask that this court give me the least sentence possible and the chance at house arrest or tether or rehab. I guarantee you will not be disappointed if you give me the chance. I show everyone I can do this. Thank you for your time.
Thank you, Ms. Hiddle. I've gone through the entirety of the PSI. I'm aware of the factual background here. I'm aware of the fact that there was a warrant that was issued. You were not on bond. So I'm going to make that correction to the face sheet of the PSI. Counsel, is there any other suggestion that she was on bond to a different in a different place?
No, Your Honor.
I didn't think there was. Mr. Seeger, any objection to that change to the PSI?
I do not.
And so it's clear to me that these circumstances happened very close together. They were individual circumstances. I've had a chance to go through all of that and to consider it. PSI has not been challenged as inaccurate. It suggests that the last time you tried to get any sort of treatment was some treatment in 2009. You've done nothing since that. So to the extent there is a suggestion that you need treatment, that appears to be clear. You have an addiction. But needing treatment and taking active steps to seek it out are two different things. And the way that the court reacts to the lack of proof of the latter, steps taken to try to get into it, is to not really consider it. If there was significant information presented to me to show that you had a plan in place for treatment, you had a bed available, for example, I would look at that as a rehabilitative factor in your support, in your favor. I don't have that information in this case. What I have is a relatively young individual, 40 years old only, being sentenced now on your fifth and sixth felony. You have 19 prior misdemeanors. You've served a litany of prior jail terms. The prosecutor counted 12. I didn't count them. And the argument that's made for you is that I shouldn't send you to jail or prison because it doesn't benefit you. Courts don't impose criminal sentences on felonious actions to benefit people. Courts are reactionary to criminal conduct. And the reaction has to be based upon a combination of what you did and the background that you bring to bear. What you did in this case, while on its face, it originally possessing some small amounts of methamphetamine is not the crime of the century, the things that involved and that circulated around that possession are fairly concerning. You possessed it, you were acting irrationally, at least according to the officers in the PSI, and you threw an item of potential, perceived by opponents, the evidence, paraphernalia, and the police couldn't even find it. It was midnight, and I don't know how hard they searched for it, but you clearly tried to interfere with the ability of them to find that illegal item, the item that I presume, by preponderance, the evidence was illegal. Yet you had many other items of illegal conduct on you. You were arrested later, attempted to be arrested, and you ran from police. You ran and hid and barricaded yourself in a bathroom and had to be physically forced out, even fighting against the police, then acted as if you were throwing up, and in what the police viewed as you're trying to, again, evade capture and interfere with the administration of justice and flush other items. Whether or not you're successful is really irrelevant to me. It's the conduct that surrounds. It's a police officer assault, resist, or obstruct, but it's the conduct that surrounds it and how it happened. And after a long history of serving prior jail terms and hitting rock bottom, I'm guessing, before. So I don't look at a jail sentence or a prison sentence to benefit you. I look at punishing wrongful conduct, taking into account whether or not there's rehabilitative potential, and I don't really see much here, and you haven't offered any proof of it. And I try to send a message to the public and to the defendants, a message that if you continue doing the same thing over and over, the penalties are going to continue to rise. Because when we have a system that's based on rules and laws, and then if you continue to violate them, there needs to be some sort of a reaction. And it's not my personal view that a reaction should be, well, prison's not going to work, so let's not do it. Jail's not going to work, so let's not do it. I think that turns the system on its head. And what I view as more fair and more reactionary to your criminal conduct is to increase penalties if you keep coming back into the court and committing criminal offenses. Particularly when you have 19 prior misdemeanor convictions and 4 prior felony convictions before these 2 felonious convictions. So the court finds that a prison sentence is warranted in this case. It's my hope that it sends a message to members of the public and to you.
Can I say something? I have called the reading.
No, I don't need to hear anything further from you, because if I allowed back and forth commentary, I would never finish court hearing. That's why there's a structure and order to it. So the prosecutor talks, then the defense attorney, then you and me. Even if I have not heard what you would say, for example, you're telling me that you may have things set up in terms of rehabilitation, the impact of your decisions, continuous decisions, still needs a response. And even if you had a plan in place for rehabilitative potential, that would not outweigh the dangerousness of the way you've carried yourself. Dangerous to yourself, the involvement of multiple law enforcement officers who had to fight with you to get you out of a bathroom, all of those things, and including, of course, the prior felony convictions and 19 prior misdemeanor convictions. The guidelines within the guideline sentence appears reasonable to me. towards the top end appears reasonable and commensurate with the circumstances of the defendant and the offenses. And so the court finds that for the methamphetamine case, 18 months in the prison system, Michigan Department of Corrections is warranted and is justified. That would be up to a maximum of 10 years. You do have credit in the methamphetamine related case of one.
A normal drive home turned into a nightmare when 6 gunshots were fired on a busy Texas highway. Now, months later, a jury sat quietly inside a courtroom as prosecutors prepared to explain why they believed the man sitting at the defense table was responsible for a shooting that nearly became a murder case. The trial began with the defendant standing before the jury as the indictment was read aloud. Prosecutors accused him of aggravated assault with a deadly weapon, alleging that while driving on a public roadway, he knowingly fired a handgun into another moving vehicle. According to the indictment, one of those bullets struck the victim, causing serious bodily injury. When the judge asked how he pleaded, the defendant answered with 2 simple words: not guilty. With that, the trial officially began, and 12 jurors prepared to hear 2 completely different versions of what happened that day. The prosecutor's opening statement immediately captured the courtroom's attention. He told the jury that this case was about a miracle. According to the state, the victim Hunter Freeman should not have survived. Prosecutors claimed that during a road rage confrontation, a bullet entered the victim's face near his mouth, traveled through his cheek, and exited just below his ear, missing vital organs by only inches. They described his survival as nothing short of miraculous. But the prosecutor said there was another hero in the story as well. A passing driver witnessed the aftermath, stopped to help the wounded victim, called 911, comforted him while he bled on the roadside, and even contacted his mother before emergency crews arrived. Prosecutors called this stranger the angel in the case, someone whose actions